Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from LexisNexis. It's the family law imprint. The book has been in print now for a year or so. It's called Child Protection Proceedings and it's got a subtitle, Care and Adoption Orders, extremely useful for members of the family law bar. Simon Johnson and Joanne Porter are the writers, and Elizabeth and I talked about the book. Elizabeth was the lead writer on this particular review, and we've given it a title, Where Doing Right is Speaking Truth to Power, Child Protection Proceedings Explained in Detail. Let's have a look at the book first. It's a paperback, and it's come to us, as I say, from LexisNexis. There's the front page. And there's the spine. As you will recall, LexisNexis took over a lot of family law titles, there's the back of the book, from Jordan's when they bought Jordan's up. The back of the book has an index which is by paragraph numbering. It's a detailed index, so you should find what you're looking for quite easily. And if I just get to the front page of it, references are to paragraph numbers. So it tells you very clearly where you are with that. The back of the book, of course, has a series of appendices. You can see Appendix 6 there. We go to the front of the book. There is the front page. It's a nice paperback, quite heavy, runs to something like 750 pages. There's the blurb from LexisNexis. Then Mrs. Justice Thies has written a most useful foreword, the end of 2017. For the book. There are some acknowledgements. The law is as stated on the 1st of November 2017. Then you've got a contents section here. The contents section is quite good. Of course, it's always useful to cross-refer the contents with index, depending on what you're actually looking for. But the contents, as I say, is quite detailed, so you should find what you're looking for quite easily. And then we run through the various chapters. You see a lot of chapters in this particular book. There we go, running through again, various pages. Right, the final chapter is chapter 30, as to be the case, dealing with appeals. And then, of course, you've got 7 appendices, all of which are extremely helpful and detailed at the back of the book. And then we go from there to the table of cases, a lot of case law, of course, in this area. And then after that, we have some statutes, the usual suspects are there. And then after the statutes, we then have the table of statutory instruments. Again, extremely useful, and I'm sure you will find what you're looking for with that instrument. There's also some international material because these proceedings, of course, do cross jurisdictional boundaries, and I'm sure many people are well aware of that. Part 1 starts with the introduction, and then you can see the structure of the book. Paragraph numbering down the side, and you've got footnoting, and there's a lot of footnoting. You can see it's not overdone, thank goodness, but there's quite a lot of it, and it gives you the actual further referencing material. All in all, I think it's an important book, and I'm very grateful to LexisNexis for asking us to review the work. Let me say what we think about it. These reviews, of course, are designed to help people, especially practitioners, find the right book for the brief that you might have. And therefore, we're trying to spot the important points that will be of help to you. A quote, "The child's welfare shall be the court's paramount consideration. This is one of 2 key principles which underpins all proceedings under the Children Act 1989. The second of which is the positive duty on all professionals involved in such proceedings to avoid delay." So there we have it. We have the basic principle, the paramount consideration, and then you have the standard requirement under the procedure rules to get on with dealing with the matter and not delaying. And of course this authoritative title, which comes to us from family law, the imprint of LexisNexis, stands out as a definitive exposition of what most family lawyers rightly regard as a delicate and difficult area of law. I certainly agree with that, having dealt with some of these matters myself. It's not an easy area at all. And it deals extensively, the book, with issues and principles of child protection proceedings, together with the everyday practicalities and procedures likely to be encountered by the practitioner. And as I say, this is not an easy area because there's a lot, as I'm sure everybody who's involved in it knows, a lot of emotion involved in this, and it is a difficult area. Now, writing in the foreword, Mrs. Justice Thies pays tribute to the commendable clarity with which the authors analyse, for example, quote, the issues that arise as any care and or placement application makes its way towards the final hearing, pausing at each stage to provide excellent practical advice. Reference is also, of course, made to the convenience for practitioners of having the relevant legal provisions and guidance to hand, as expounded by the book's two knowledgeable and expert authors, Simon Johnson and Joanne Porter, who are both specialists in family law. Now, throughout more than basically 800 pages when you include the index and so forth, and 28 chapters, the book covers virtually every conceivable aspect of the law and practice pertaining to child protection proceedings, from general principles to adoption, and as we saw at the end, appeals. And obviously there are 28 main chapters. Obviously there's the introduction and so forth. Referred to throughout are the duties and responsibilities of a local authority tasked primarily with the protection of the child. And again, that's of fundamental importance to those involved in these proceedings, whether you're new to the proceedings or whether you've got some substantial practice in this area. And on this point, and in almost every circumstance, the practitioner, in the words of Sir James Mumby, in a case in 2017, must be mindful that there are occasions where doing right means speaking truth to power. And I think that, again, is an important point which I believe the judiciary generally do bear in mind, because they are aware of the role of the local authority in any of these proceedings. The entrance to the Old Bailey, he continues, this is Mumby, admonishes those who enter to defend the children of the poor, is less required of the family court or the family division of the High Court. I think not, and that basically is his point of view, and it's useful to quote that. You often see that when you have a standard shot of the entrance to the Old Bailey. In fact, that's the old entrance, which is now closed off, and you have to go through security. I can remember the days when we went through and there wasn't any security at all, but that's a long time ago. Offering their perspective on these remarks, then, this is the remarks of James Mumby, not my remarks, the authors of this text comment that the ways in which judges at all levels in the court system have striven to apply these sentiments within the framework established by Parliament and by judicial precedent is the real subject of the book. And that's what you're getting. And I think anybody, as I say, involved in this area should be aware of the book, and I think they will find it of some help. I certainly, although I use the red book, I certainly use these other publications from LexisNexis as well, because they complement a picture for me of where I'm going with the case. And I think that's important for counsel and solicitors to bear in mind, just as an observation by me. Now, to that end then, the book functions as a useful and certainly accessible work of reference, with a helpfully detailed table of contents and an index and numbered paragraphs throughout. You should find what you're looking for pretty quickly. Especially useful, I thought, are the 7 appendices, which include, for example, key extracts from the Children Act 1989 and the Adoption and Children Act 2002. And also do note the 20 pages of cases, statutes, statutory instruments and the international materials. Basically, a lot of that will be included whether we leave or whatever happens with Brexit. We're in for the long term now with a lot of international materials as we become much more global. Let me conclude by saying this. From family law practitioners to social workers and local authority personnel, anyone involved professionally in this complex and sensitive area of law will doubtless regard this book as essential. I certainly do, and I think it's an important book to have. Let's just have another look at it. There's the front, there's the spine again, and then on the back there's just a little bit of blurb about what's actually in the book itself. I probably can't see it too well. Opening it up in the middle, this is the final hearing, practical considerations. So what the authors have done, and I think it's again important, is anybody who's involved will probably need some additional help. And this, for instance, this paragraph here, witnesses requiring special measures, mental health issues particularly is highlighted there, and I do think it's very helpful. Ground rules hearings, that's mentioned. Again, you may have heard those expressions before. Tries to set the scene as to what you do and don't do. Then cross-examining of experts, again very useful, and so on. You can see the structure of the book. And then we go to chapter 21. You see the paragraph numbering, and then of course, as I say, you've got in some cases quite a lot of footnoting, but it isn't overdone. So a big thank you to Simon and Joanne for producing this work, and for LexisNexis for the imprint that we have for family law. It makes our lives a great deal easier. So a big thank you to everybody involved in this publication. Bye-bye.